two federal courts recently determined that tax-exempt status is a form of federal financial assistance, which would require thousands of schools to follow federal guidelines regarding sex and gender for the first time. What does this mean in practice? Will religious schools be required to comply with pronoun requirements? Will they be required to comply with allowing boys to compete in girls' sports and integrated locker rooms? Joining me now to discuss this is Greg Baylor, Senior Counsel and Director of the Center for Religious Schools at Alliance Defending Freedom. Greg, good to see you today.
Good to be back with you, Joseph.
Well, it's good to have you. Give us first a little background on these cases that led to this decision.
Sure. There's one case in California, one case in Maryland. In the California case, a Christian high school declined to play a tackle football game against another school that had a girl on its team. This girl and her parents were apparently unhappy with that, and they retained an attorney and sued the Christian school. Now, they were looking for a legal theory, and they wanted to allege that the school had discriminated against her on the basis of sex. And normally Title IX, which is a ban on sex discrimination, would not apply to this school. Why not? Because Title IX only applies to those schools that get, quote, federal financial assistance. Yeah. And this school received no federal money of any kind other than tax-exempt status, which we'll get to in a second. In the Maryland case, there were a group of girls who had attended a private religious school, and the allegations in their complaint say that they suffered from sexual harassment and sexual assault at their school. They also were looking for a legal theory to assert against the school. They wanted to assert Title IX sex discrimination, but they faced the same problem as the football playing girl out in California, which was that this private school isn't really subject to Title IX because it doesn't get any money from the federal government. So they too came up with this creative argument that the school's possession of tax-exempt status makes them subject to Title IX.
Well, my first reaction to some of those facts is that it's interesting that they seem to be implying that the federal government could require boys to play in a football game that they were uncomfortable with for some reason. And that seems like a strange power for the federal government to have. But nevertheless, the argument, the conclusion of the courts, if I understand this right, is they said it is a federal benefit for them to be tax exempt. Is that correct?
Yeah, that's exactly what they concluded. They said that merely possessing tax-exempt status is no different than getting a grant or a loan or a scholarship, actual dollars flowing from the federal government to the educational institution. This is virtually unprecedented. The Department of Justice's own guidelines for this sort of thing say the tax-exempt status is not federal financial assistance and thus does not trigger all the obligations that come with Title IX. And as you well know, there are a number of schools prominent schools at the higher ed level, like Hillsdale and Grove City, that have explicitly and intentionally denied or refused to take federal money because they wanted to avoid all the obligations and red tape that come with Title IX. So, and then there are thousands of K through 12 private schools who have no connection with the federal government other than their possession of tax-exempt status. So this is a truly unprecedented, shocking decision.
And one of the things that's concerning about this, of course, is because the First Amendment, this wall of separation of church and state that we hear so much about, that it's used to try to stop the Christians and the church from influencing the public square. What we certainly know it exists to do is to stop the state from micromanaging the government or the government from micromanaging the church and how it operates. This seems to be something of an end around of the First Amendment, where it says, well, because you're tax exempt, therefore the government has the right to regulate how a religious organization operates. Is that a fair interpretation?
Well, they're certainly making an end around what Congress intended. It's very clear that Congress did not intend, when it wrote the words federal financial assistance into the statute, they didn't intend for every private school in the country to be governed by Title IX. Now, one of the good things about Title IX is that it does have a very robust religious exemption, which does reflect, of course, First Amendment principles. But schools like these shouldn't have to invoke the religious exemption because they're not subject to Title IX in the first place. This just creates more litigation and liability risk, not just for religious private schools, but for non-religious private schools as well.
Now, I understand we're talking about Title IX in education right now, but if this precedent were to stand up upon review, do churches themselves face a potential threat because they have tax exempt status and therefore that would be seen as a financial benefit from the government?
Yes, they are, because Title IX is not the only statute that imposes a non-discrimination obligation on recipients of, quote, federal financial assistance. There are a multitude of statutes that have that trigger on them. The Rehabilitation Act, Section 504 of it, Title VI of the Civil Rights Act of 1964, the Age Discrimination Act of 1975. These are statutes that churches and most schools have never bothered to think about because they've never been subject to them. Now, hopefully these two decisions will be reversed on appeal, and this sort of reasoning won't spread to other states and other jurisdictions, but we'll just have to watch and see if it plays out that way.
And Greg, in our final minute, tell us a bit about that. What is the schedule? What is your expectation in these two independent cases that apparently considering the same question?
Yeah, well, in the Maryland case, the school asked the judge to reconsider. And most of the time when you ask a judge to reconsider a decision, tell them, hey, you got it wrong. They normally don't grant you that opportunity. I was encouraged to see that the district court judge in Maryland did agree to hold a hearing and reconsider this decision. There was a friend of the court brief filed by a number of associations of private schools saying, Judge, please reconsider, don't do that. That's going to happen on September 1st. And unfortunately, the California case won't be able to move as quickly, so it might be quite some time until the Ninth Circuit reviews that court's decision. But we'll pray that these appellate courts will get it right, or even that the district courts will change their mind.
And we will pray with you. Greg Baylor, Alliance Defending Freedom, thanks for stopping by today.
Thanks, Joseph. Good to see you.